Hello, everyone. I was hoping you could hear me all right, but I guess you can. My name is Dr. Colston. I teach at Duke University, and I'm especially honored to be here with you all. I want to give my thanks to the steering committee and to all of you faculty and staff here at Greensboro Day School, as well as to our parents, friends, and visitors for putting up with this talk, which, if it is disappointingly abstract, hopefully it will be refreshingly brief. I guess I should start when talking about diversity and any kind of pluralist ethic that brings us here today, with, I guess, my own story. I'm embarrassed to say I was one of those theater kids. And I did it a bit more than just as a requirement. Back home, back out west, I'm originally from Southern California. And we had to, of course, have our theater classes. And I had no singing talent, and still barely could, I try to keep a note, but people who have more experience are like, oh, Aaron, please, let the professionals do the thing. And I had to do a play, and that was, the compensation. Okay, if you're not going to be in chorus, then just do the play. And the play that I was in was, some of us in this audience might remember it, 12 Angry Men. Yeah. Well, we thought we were clever, and we called it 12 Angry Jurors. It was a rather diverse crowd. It was me, and we had women, and this wasn't just 12 angry men. We were all angry, but we were not all men. And, it had been a movie, but before that it had been a play, and there's all these different versions. Apparently one of my friends, she teaches in Russian literature. She just retired over at Duke. She says, actually, there's a Russian version as well. So anyway. And hilariously, I had to be juror number 11. And I don't know if you guys remember the play, but juror number 11 is the one who, in the stage directions, it's required to do a European accent, whatever that means. And, I'm embarrassed to age myself a bit, but I, at the time, Arnold Schwarzenegger was the governor, so I thought I would try and do a kind of Arnold Schwarzenegger accent, while I was juror 11. He's really the governor top, get into the chopper, right? So I thought, it's like, the purpose of juror 11 in the play, what does he do? He says, it's like, one of his lines is like, I thought that what is important about America is that you get to have your say, you have a right to say what you feel is on your mind. And I thought it was very, because like, you're not going to expect a black governor, you're going to expect a black, right, Arnold Schwarzenegger, right? So at the time it was very funny, but I don't think people really caught on to the point of juror 11 within the play. They've all had these different kind of psychologies, right? Juror 11 is this outsider who reminds these insiders, like, hey, it matters that you can serve on the jury. It might be a bit exhausting, but it's a privilege and something that we're guaranteed from exclusion now. It's important that the jury has changed. Juror 8, he's the procedure guy. He really wants fairness. Anyway, and so I think my accent kind of got in the way at the time. And so I kind of always thought, like, maybe no one really got the point of juror 11 when I was on stage and had that kind of hilarious role. So when years later, I started, teaching at Duke, I had an opportunity to teach a pre-college class. Sometimes we do this. We step away from our undergraduate teaching and we open to a much wider audiences. And I was lucky to be able to teach a pre-college class on social psychology and law. And the academic team insisted. They was like, Dr. Colson, if you are going to teach this class, please, do not make it too abstract, do not make it boring. You have all these kids, their parents have spent all this money, and they don't want to be bored. Make sure they're learning, but don't bore them. And I was like, okay, well, I'll try not to be. Thanks for saying that I'm boring, but I'll try not to be boring. Anyway, so I immediately thought, aha, how on earth am I going to get social psychology and law to make sense? These are very different, but of course, related fields. And how do I make it not boring? Instead of just throw a bunch of readings at these kids about jury psychology and, the shifting nature of the Constitution, blah, 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 blah. I thought, 12 Angry Men, ha-ha. It was actually kind of interesting. Some kids, you gotta be careful. You can't be an angry man with some kids. Like, I got a little angry once, and the kid's like, ah! And I was like, oh no, it's just part of the play. Anyway. So I finally was able to say, okay, these are the point of the different juror characters, right? And we had a really interesting time. Part of what I wanted to get across with teaching that class was, social psychology and law are really interesting because one is interested in this kind of social scientific empirical exercise about observing human behavior and seeing how we might be able to build models relatively predictive but more or less explanatory about human behavior. Whereas the law is about what are fair rules, where do rules come from, how do we interpret rules in relation to particular circumstances. So the social scientific empirical element and this normative interpretive element at times can be in tension and are not obviously related. They're related, but it's not obvious how they're related. When I started on that kind of angle with the kids, I could see them like normative, social, empirical, blah, blah, blah. And so I did my best to sort of push through some of that, and I was able to finally introduce them to 12 Angry Men. And the room kind of opened up a bit, because you get them thinking about what it would be like on a jury, and the kind of feeling that comes with having to agree with people who think they know what reasonable doubt is, or what even a reasonable person is. And obviously this person couldn't have used the knife that way, blah, blah, blah. You're an idiot. And like, what do you mean I'm an idiot, right? So you gotta get the kids sort of the feeling what it might be like to wrestle over what should be obvious, but is actually not obvious. That's essentially the plot of the play. And, we had actually quite a bit of fun seeing that, well, look, this play was written way back in the 40s. And there's all kinds of bits in there that make you feel like, oh yeah, this is really dated kind of language. But it turns out, a lot of the kind of reasoning structures and reasoning problems that pop up in the play, you actually will see if you pick up, any textbook on jury psychology or people talking about critiques people have about the jury. The reasoning problems are what? Cognitive burden. It's actually hard to put facts and arguments together. When you've got opposing counsel going back and forth over such and such issues, turns out, right, people who are watching this have to piece all these facts together. And it's not easy to do if it's not your job. What's another thing? Oh, sometimes when you tell them, well, actually this is inadmissible evidence, they might pay more attention to it. They'll be like, well, why can't we, what do you mean it's inadmissible? Who do you mean? Yeah, I can't think about that. So there's a really interesting backfire effect that sometimes happens. What's another one? Sometimes people might have an outsized view about defense or witness, or who's, right, or the judge. They might have all kinds of, outsized views about, who's on the defense stand or who the witness is. And, for me, right, it's super interesting already that this seems to be a case of art imitating life. The story, behind Reginald Rose's play is he literally was on a jury back in 46, 47, and then he wrote about what happened to him. And one wonders if the people in, 12 Angry Men literally were people that he remembered from his time in the jury. And, we should be careful about trying to say, oh, well, now we can go back to all of these true stories and do this verification work. Like, it would have been in this courtroom, and it would have been in this neighborhood, etc., etc., etc. That's doing probably too much. But the way that, the reasoning styles and difficulties that people have, right, in juries literally decades later, is actually kind of cool. And so I wanted to wrestle with the kids on this. And, so we read the play, and I said, oh, look, juror number 3's basically got the super predator myth going on in his mind, and yada, yada, yada. Kids like, oh, that's kind of cool, blah, blah, blah. I wasn't happy. I was happy, but I wasn't satisfied. That's what I'm saying. I wasn't completely satisfied with it. I was always going another level. Why? Well, we had 2 weeks, we had a bunch of time. I had them from 9 to 4. It was a long summer class. And so I thought, okay, let's go even further to what it even means to think about procedural justice. The jury is a procedural construct. It's something that we inherited from the common law. But there's this internal element of all these personalities going back and forth. And I wanted to bring in all these questions of sort of moral, legal, and political theory to talk about why this play and the observations we might make about jury psychology matter. So I did what you usually have to do, which is talk about John Rawls. Oh my God, everybody talks about John Rawls. The Theory of Justice. It's a book, oh man, it was back in 75. It's great. I mean, a lot of great stuff came out in the 70s. And one of them actually is A Theory of Justice. Rawls is obsessed. He's obsessed with the idea of there being a pure procedural justice. And I bet you could guess why I would have some skepticism about that, and why I wanted to introduce students to a level of skepticism, a reasonable, I think, degree of skepticism about it. Rawls, he wants to continue the contractarian tradition in the development of moral and legal and political theory, right? The big three started off. You get John Locke, Jean-Jacques Rousseau, and Immanuel Kant, right? Thinking about agreement and rationality and the a priori and categorical imperatives and the general will. All these really crazy, huge, big political words that we build constitutions on, literally. Before you start a government, you read Locke or Rousseau or Kant. And so, Rawls is kind of on some important stuff. He's poking at these guys. He's like, these are the big three. Before you start any legal or political regime, you have to read. And his thing is like, I will go even further of abstraction than these guys. Instead of talking about the state of nature, I'll talk about the original position. The original position. The original position from which all agreement, if it should ever try to create a procedure where all results will be fair, must begin at an original position. Now, how on earth are we supposed to get to this original position? He tries to give us a clue. The veil of ignorance. All parties, before they will come to this agreement, must enter into the veil of ignorance. What do we lose on the side of the veil of ignorance? All social identities that put people at odds, arbitrary social contingencies, your status in the difference of generations, your social identity, your wealth class, all of the things that put people at odds. That's what we're supposed to let go of when we go into forms of reasonable agreement, ones that we would hope to mirror an original position from which all foundational agreements are supposed to come out of. And look, I mean, on one hand, you get a view of what makes the law, right? This idea that there's some sort of original position when you have, right, a constitution. We the people, original position. That's essentially the kind of language that Rawls is thinking about. But some skepticism is warranted, at least from the perspective of psychology and law. It's like, well, wait a minute. Where's pure procedural justice? The reason people are brought into jury duty is because we hope that the kinds of repair that that we're called to as serving on a jury, right, are supposed to come from experience. And reasonable doubt is supposed to have a metric of people's experience in it. And we would hope that these experiences are not only one kind, because we would want a kind of maximum set of experiences to understand what kinds of reasons are at work. So, this pure procedural justice, on one hand, gives us a reason why or how the law operates as the law. But when you actually get into the practice of determining what's a fair ruling, there's all these really bounded social elements that are especially important. And Rawls as a contractarian, he kind of loses some of that. And other views about where fairness and justice come in are useful for giving us leverage on the kind of constraints that we should have whenever we're dealing with the kind of normative work, these big normative works that Rawls and other philosophers are interested in. I think the main lesson from this, if there's a lesson, is, look, diversity or any pluralist ethic is hard. Just is. And making an institution or any kind of procedure or practice diverse is not going to solve every problem, right? It might actually make it more difficult because people come from different views, obviously. But I don't think that means we should drop the project, because that's a good democratic virtue. And I think it also means that whatever we come out on the other side of being more pluralist would actually expand the horizons of fairness. So I think, a lot of us have this invitation, not only by serving on juries, but I think by embracing diversity, as we're called to do by our Greensboro Day students, to ensure that, instead of narrowing the horizons of fairness, we expand them. And I think that's a position that's even better than some original position, but I think a better future. So, thank you all for